and liquidations. So us economists, after the pandemic, have had a really hard time to understand how to forecast insolvencies. Before we used to be able to do it in a more or less, good manner because we could tie it to GDP growth. And when the pandemic arrived, you had GDP that just crumbled everywhere, obviously, complete shutdown, but you had no insolvency because there was this massive state support, obviously. And so when I looked at South Africa specifically at that point, it was kind of the same, except that in South Africa, the lifeline did not really last for very long, and then the economy was allowed to operate normally again. A bit what happened in the Anglo-Saxon world, and it's really in the European countries that we had this massive life support. So first of all, my first question to you is that, can you give us perhaps a bit more insight into how liquidation and insolvencies in South Africa work, perhaps because we obviously will talk about what's happening more recently, but maybe with a longer perspective, how has it been historically? How did this question of insolvency evolve? Because it is absolutely fundamental to the economy, but also to the society and for politicians in the case of business closures that really create social tensions. So what's the scene in South Africa and how has it been?
Thanks, Aroni. Can you all hear me? So good afternoon to all of you, and I want to thank Coface for inviting me and for Aroni to including me in this afternoon's discussion. So believe it or not, I've been involved in insolvency since 1991. So that's 33 years involved in distressed companies, seeing a lot of closures, a lot of fallout over a very long period of time. And I must say that I'm not the most popular person when it comes to dinner party conversation. Generally, people try and avoid me, but I've got quite used to it, and I don't take it very personally. So before 2011, all we could do with companies is put them into liquidation. And it was a very negative outcome for South Africa, particularly for companies that were distressed. And obviously, the number of liquidations would go up and down as the years went on, pre our new 1973, or post our 1973 Companies Act and pre our 2011 Companies Act. So the status quo was not a good place to be. We would, in the early days, apply to court, Aroni, on a Tuesday for companies to go into liquidation. And what did that mean? A shutdown of the company, obviously jobs coming to an end, suppliers not being able to continue to supply goods and services to those companies that went into liquidation. So in 2011, in fact in 2007, government started talking about a restructuring regime, similar to what you see in the US, which is Chapter 11, in Australia, administration, Canada, and elsewhere. And South Africa got our new Companies Act in 2011. For me, a very positive outcome, because what we could now do is restructure companies through a formal regime called business rescue. Not rocket science. I mean, business rescue is quite clear in what its intentions are, and really it's all about rehabilitating companies that are facing the cliff of liquidation. And we pulled back after 2011 dramatically in respect of company failures. And again, liquidations were the fallback position. Liquidations were extremely negative. Minimum dividends were available to unsecured creditors because the banks generally were all secured, having taken their security. And banks would normally come out well, but unsecured creditors not. And we were really busy with liquidations, but once business rescue arrived in 2011, it was a complete change in sentiment. And you won't believe it, but our business rescue legislation was in fact drafted by the Canadians. Why that is, I still don't know. But the Canadians came along and drafted our business rescue legislation. So looking beyond 2011, it has been a game changer and clearly a no-brainer in respect of trying to give companies a different option to restructure debt. If a company goes into business rescue, clearly the biggest focus has to be compromise of historical debt. Give the company an ability to compromise their debt move forward, give the company a fresh start, and be able to trade into the South African economy going forward. And compromise of debt was something which mirrored what we saw in foreign jurisdictions. So I think in the last, let's say, 13 years since we've had this legislation, we've seen some good results. We've certainly seen some big fallout, and I've been involved in quite a few, believe it. I must say, South African Airways, Edcon, Comair, which went into business rescue and then into liquidation, Tongaat Hewlett more recently, the South African Post Office, and Ellie's is another example. And it's an ongoing situation. I've recently been very involved in Murray and Roberts in the construction industry, which again is reflective of what you've been talking about, Aroni. Unpack, for example, went through an informal restructuring process. They in fact appointed a chief restructuring officer who worked on the restructuring of Unpack for a period of 2 years, and now the company is continuing to trade, I'm hoping, quite well. And business rescue is not reserved for large companies. Small, medium enterprise companies also file for rescue. We've seen the likes of Westpac, AutoZone, Cross-Trainer entering the business rescue process. But Aroni, what does scare me a little bit, even though liquidations might be down, if you look at it since 2019, in this last year, 2024, we had over 1,500 companies file for liquidation in South Africa, despite the fact that we've got business rescue as an option. Now, why did so many companies have to go into liquidation? Now, there's all sorts of reasons. It's sector-driven. It might be economy-driven, certainly load-shedding driven as well. But a lot of those companies, if the directors and management understood the option of a restructuring process like rescue, we might have seen a larger number of those companies, in fact, file for rescue and maybe even have been rescued or restructured rather than go into liquidation. So those statistics are quite frightening. When you talk about SOEs, Eskom is what it is. They've lost more than 20 billion rand in the last 7 years. You've got other state-owned enterprises like the SABC, PRASA, Petro South Africa, Denel, all consistently making losses over a lengthy period of time. Now, we all saw SAA go into rescue and it's come out. Yes, it's still flying. Some will argue whether that's a successful rescue or not. I'm not sure. But the company is flying. The airline is still flying. And again, business rescue post our liquidation era is a very positive outcome for companies. Yes, you have to maybe diminish the size of the workforce, maybe through retrenchments, but ultimately the objective of government in introducing rescue was to keep jobs, was to preserve jobs in this economy. And I think it has worked to a large degree. And just to end off, Aroni, it's completely agnostic, can affect any kind of business. I know you put up some statistics there of manufacturing, let's say hospitality, airlines. It really does affect everybody. I think it comes down to management, the ability of management, whether your board is functioning correctly, and whether or not your creditors or suppliers are in fact supporting the company through, let's say, a distressed period.
So actually, I think that that's a very interesting aspect, because as you said, like, yes, I mean, we have had, I mean, although if you compare the levels to, pre-pandemic levels, they're relatively low, but we have had an important number of liquidations this year. And I think one of the points in which you can really give us an insight, and which I as an economist certainly don't know, is how do boards, how do directors approach a situation of distress? We'll not call it a liquidation immediately. Their company is distressed. They can see that it's distressed. They can see, depending on the size of the company, that it's going to affect a large amount of their workforce, perhaps the entirety, the economy, that it's then is going to perhaps in some cases become a political it's going to become a political issue, because the politicians will have to get involved because of this importance of the industry. I mean, we saw what happened with Arcelor, and it's not even in that category. It's like site closures. Similar, but still you have job losses. So, yeah, my question is, how do boards approach this distress, and ultimately, like, what leads them to liquidate, what leads them to go into rescue? How do they approach this question? Because I think that is someone that only people who are close and who know the people who are the executives would know. How do they approach this situation?
So, Aroni, I always think of a quote from, I think it's the Ernest Hemingway book, The Sun Also Rises. Question was asked in that book, how do you go bankrupt? And they say in two ways. One, gradually, and then very, very suddenly. And that's really the story that faces directors of companies that are trading in distressed circumstances. And in South Africa, if I could lecture boards of directors every week, I'd love to do that. But I can't, because they're not going to come to my lecture. Directors are not going to put up their hands to be educated on Chapter 6 of the Companies Act. But it's about the responsibility of directors to recognize, I think, warning signals. And those in the credit insurance industry must understand that directors' education levels on their responsibilities, statutory obligations, and what they are expected to do on the board. Never mind non-executive directors. I'm talking about directors who are executives who should have a proper understanding of the Companies Act. You'll be amazed how many have not read the Companies Act and don't understand the machinery of what can happen when it goes wrong. So it's about timing, and it's about reacting to warning signals. And warning signals are not necessarily rocket science. I mean, it all comes down to cash flow. Can you pay your creditors when in terms of your credit terms? Is it 30 days, 60 days, 90 days? Are your suppliers backing you in respect of extending credit terms? What does your management look like? Is there fallout at trade union level? Is the rand affecting your ability to trade profitably? Are your exports up or down? It's a whole lot of things that go into a basket of what we call distress. And as I think the ability of directors to recognize those red flags or those warning signals, which will enable them to take advice at a much earlier stage, both from their financial advisors, from their auditors, and from their legal advisors. And a lot of directors don't understand that if they do not take advice at an early stage on the distress curve, and they don't want to be there, they want to be obviously at a much earlier stage, I think they will face very, very pertinent questions if the company defaults into a liquidation. There's something called a Section 417 inquiry. I don't know if anyone's ever had the misfortune of being in an insolvency inquiry. It's not a very pleasant place to be. Some very difficult questions can be asked of directors. Why did you wait so long? You knew the fact that you couldn't pay your creditors in terms of your credit terms. Why didn't you get advice on a business rescue or restructuring? And those are the difficult things that directors have to deal with. So it's about reacting to warning signals, looking at what options are available, and you don't necessarily have to rush into a business rescue. You can go through an informal restructuring. I spoke about Unpack a bit earlier. There they appointed a CRO, a Chief Restructuring Officer, who sometimes comes onto the board, or someone who's independently consulting to the board to assist the company through its distressed phase. And that's something which is happening often in the US and to a degree in the UK. So again, not easy for directors of distressed companies.
So, let's say that one director has got the signals. He has the signals that clearly there is an issue in his company, but he does not take the necessary steps, and this, let's say, hypothetically leads to a situation where there is liquidation, there is considerable amount of job losses, there are creditors that are not paid, and so in South Africa, how is their personal liability also engaged for directors who miss the step or who willingly do not take it? Because it's not always that they have not understood, it's just that they didn't do what was required, right?
Aroni, I wish I could give you a list of cases where directors have been held personally liable, but I can't. In fact, one of the last companies that went into liquidation where directors were held personally liable is a case called Philotex, Philotex. where directors were in fact held personally liable for the debts of the company because they traded their companies recklessly. They knew they couldn't pay their creditors, but kept kicking the can down the road, and eventually the company collapsed into a liquidation. And in fact, some of those directors were sequestrated, declared bankrupt because of that situation. I think personal liability is something which is real, but not taken seriously enough by directors. But I think there's a nuance, Aroni, which directors are scared of, and that's the loss of control. So if you're facing a business rescue, for example, and we'll get into the detail just now, but a business rescue means handing over the reins to an independent person who's going to scrutinize what you've done. It's not liquidation. It's a company that continues to trade within the restructuring mechanism of a business rescue. But all decisions now have to be made by the business rescue practitioner. And that's not something that directors accept very readily because they lose control. It gets a lot worse, obviously, if it goes into liquidation because directors then lose their position completely. So I think the fear factor of personal liability, of losing control, is something that should keep directors awake at night.
I do think that it keeps them awake at night, but then in the end, like sometimes when you see these cases in the news, you just wonder like how is it possible that considering everything that's happening around the world, considering all the information that we have, considering the economic presentation they saw at a conference like this was clearly telling them that their sector was under duress. Why is it that you end up in a situation where you just completely lose control and then your personal liability is engaged, and then it's really something that's puzzling, on an economic point of view. So before we delve into the deep subject of business rescue, there is one thing I would like to talk about, which is zombies. Because I think it's a very important and interesting part. So I'll let you explain what a zombie is, but on an economic point of view, we saw that the number of zombies increased during the pandemic simply because there was so much life support that was poured into the economy that companies that should have died, because there is also in economists, it's like the creative destructions. You have companies that die that leave the space to companies that are more profitable. That's just how the economy works. So there's always a natural level, quote unquote, of insolvencies in the economy, just because that is how you have profitable companies that cycle. So we saw an increase in zombie in some of the zones, such as the EU. So what about zombies in South Africa? How did this aspect evolve of these companies?
So a zombie company, it sounds like something out of Netflix, but it actually is a real term. I had never heard of it pre-COVID, but after COVID, I certainly heard about it. And really what it's about, it's a company that's caught in the headlights, like a rabbit caught in the headlights, doesn't really know which way to go. And you've got weak management, probably a weak board of directors that keep kicking the can down the road in a company that really is not growing, is not really making the profit margins that it should be making, and it's just basically treading water. And during COVID, all the COVID loans that were granted to these distressed companies because of an inability to trade kept a lot of these companies afloat through a long period of time. And South Africa was no different. COVID loans, both from the banks, the local banks, as well as from government, kept a lot of companies alive for a period of at least 2 years. And a lot of those companies after the COVID period should have in fact have been put into liquidation, never mind a business rescue. There was nothing left to rescue, only because the company was trading with very, very limited resources. The ability of management was very weak, not generating sufficient revenue streams. And it was those companies which in fact were sucking resources out of the economy, which should have probably been put into liquidation. Now it seems harsh, but when you look at 1,500 companies went into liquidation last year, a lot of those companies maybe could have been rescued, but there's a lot of companies that deserve to go into liquidation because there was no real opportunity to rescue them. So I think in today's world, when you talk about zombie companies, they still exist for different reasons. Take Cross Trainer, for example. That's a company that struggled so badly during COVID that it had to go into rescue, and very shortly thereafter, late last year, went into liquidation. And when you look at the reasons for that company going into liquidation, it was very much generated by the COVID pressures. So not much has changed. I think if you look at it holistically, zombie companies, if they are not contributing and are not really growing in any way, should be in fact put into liquidation. But the directors have to be brave enough to make the decision.
Exactly. And that's one aspect. I mean, obviously, generally speaking, when we speak to clients or brokers or partners, when we talk about liquidations and insolvencies, it's a frightening subject, because it means that obviously, like, it's risks on your portfolio, it's risk of non-payment. But the reason why like we wanted to talk about zombies is also to give a grasp that some companies have to go insolvent for the economy to continue working, because otherwise they're eating up resources that could be otherwise being stimulating an economy. So I think that that's really the key aspect of zombies, and it's not very well known as a term from outside of the economic world. Sometimes it's good to give a bit of this nuance to the insolvency, that there is a level of insolvency that's natural to an economy. So now for like the last part of our discussion on business rescue itself. So as you said, in South Africa, on a very macro stats level, we do see that the level of liquidations remains relatively low, but because, as you said, there is another option, right? There is another option, which is business rescue, and which is, I mean, the fact that directors can choose to go through, yes, a complicated process. Yes, they have to hand over control of their company to a third party, but at the end of the day, they remain in business, and the company floats. Like, it's just like a boat, right? The company keeps floating. So first of all, like, can you explain to us how exactly the business rescue procedure works in South Africa? And then perhaps, like, what are your conclusions after it's been, what, around 15, 13, 14 years that it has been implemented? So what are how is business rescue faring in the South African economy as a general practice?
So business rescue is nothing more than a restructuring tool. That's really what it is. I explained earlier, a company can go into an informal restructuring, a business rescue, or liquidation. So really what it's about, Aroni, it's about handing it over to an independent expert, being a business rescue practitioner, who comes in appointed by the board. 80% of business rescue practitioners are appointed by the board of directors when they are financially distressed. In other words, the company cannot pay its debts in the ordinary course of business. It's financially distressed, and the Companies Act says, if that's the position, you must file for rescue. Practitioner would come in, he would look at the company, he'd obviously engage and consult with all stakeholders, employees, trade unions, suppliers, the management, the existing board of directors, and obviously manage creditors, because creditors know once the company is in rescue, they're going to get a debt haircut. They're not going to come out whole. If they owed R1 million, they might get 20 cents in the rand, 30 cents in the rand. But it's still better than zero, which you'd probably get in a liquidation. So that's the sale that the business rescue practitioner has to do when appointed. And you've got good business rescue practitioners, and you've got very average ones. And I think some of the average ones probably give business rescue a bad name. And obviously the bigger matters, as I referred to earlier on, Tongaat Hewlett, there's a lot of litigation going down on that matter in KZN. But take Edcon, for example, a really good outcome for a company that went into business rescue and ultimately was sold to third parties. And those companies are still trading today. Edcon as a business is owned now by TFG, and certainly Jet Stores is also sold out of business rescue. So we've had some really good examples of success. Now, the most important element that people need to understand is the moratorium. Once a company goes into business rescue, you get a breathing space. The creditors cannot knock over the company. They cannot put the company into liquidation. They cannot get judgments against the company. And they can't apply to liquidate the company. So the practitioner gets the space and the breathing space to put together a restructuring plan, which is really a contract between the company and creditors dealing with compromise of debt, maybe selling the company to a third party, maybe restructuring the company maybe restructuring its board, maybe restructuring its management, maybe renegotiating prejudicial contracts, like, for example, very prejudicial leases. That was done in the Edcon situation. They closed down, I think, 50% of the stores where they were making real losses. And as a result of that restructuring, the company was able to be sold to a third party. It really is something which is dependent on the buy-in of stakeholders, of the confidence levels that stakeholders have in the business rescue practitioner. And I must say the banks generally back a business rescue. They don't want to see their customers go into liquidation. And generally suppliers as well. They don't want to see necessarily a company fail, because that's one less company they can supply goods and services to, which doesn't make sense in an economy like South Africa. So I think it's a positive tool. We've had some really good examples of companies that have gone through a business rescue. Some go through a rescue. There's no backup of, let's say, post-commencement finance, which is nothing more than further loans given to the company on a preferential basis. And if you don't have further loans being provided to the company must default into a liquidation. So I'm not sure if you've got that slide that you want to, if you could just put that up quickly. I just had no, not that one. That one. Okay, so really that just shows you, Aroni, what it is. It's a diagrammatic explanation of the business rescue process. So I divided it up into 3 sections: predict, prepare, and preserve. If you look at the graph on the left-hand side, the company has a life cycle. It starts off trading on the bottom left-hand side of the graph, goes up, commences trading, and generally companies are propped up by loan funding by its shareholders, but it can reach a stage of stress. And when it reaches a stage of financial constraint, that's when you need to start, as directors, thinking about appointing an independent business rescue practitioner, or at least a consultant. And that's the prepare phase. You'd prepare for the company to go into a business rescue, obviously get the right people on board, do a pre-assessment to see whether the company is in fact a candidate for rescue. Maybe it should default into liquidation like a zombie company. And then the green section is the preserve phase, and that really is preserving value. And that's where you'd file your plan, make sure that the stakeholders approve the plan. It's got to be voted in at 75% of all creditors voting in value. And then at the top right-hand side of the diagram is the exit. And that's when the business rescue practitioner would either allow the directors to continue, maybe under new management, maybe under a new board, or possibly even selling the company to a third party. So I just thought I'd share that because it does give you like an overview of how business rescue actually works.
It's fascinating, actually. And so this, I mean, just to conclude briefly the discussion, and then I think that if we can open the floor to questions, that would be interesting. I think that one of the most interesting aspects in this is that the fact that this legal framework was, first of all, invented or pushed through to enable the business rescue is perhaps what has kept liquidations under check or prevented them from really going out of control. Whereas if you see the economic picture that I painted of South Africa, like in the past 4 years, naturally there should have been a rise in liquidations because economic growth was really low. But due to the structure of this South African economy and the possibility of business rescues, perhaps some of these liquidations were avoided. And I think it's particularly interesting in the sense that what I was touching on earlier is that some of the South African industries are going to face increased competition and are going to see dents in their profitability, because that's just what a more protectionist and fragmented world brings. And so the question is, well, how many of these companies will actually have to liquidate because they cannot survive in this world? But how many will be in a situation of distress and will be, will use business rescue as a tool and perhaps also use it not only to stay afloat, but perhaps then to redefine their strategies, their model, so that can be an encouraging factor, that you have this procedure that enables you to shift your priorities in a shifting world and then perhaps stay afloat. So I think that that's at least the fact that there is the legal framework that enables that is perhaps a sign, a positive sign at least for the corporate sector, that they know that they have the option, even if conditions are difficult, you know.
Aroni, I think it comes back to what I said earlier. It's about being prepared, and that's why I have a preparation section on the slide. But really, it's about warning signals and being astute in relation to what's coming down the road. Now, I talked about financial distress earlier on, and the Act talks about a 6-month window. It says, not insolvent now, you're not insolvent in a month. What will your position be from a cash flow perspective in the next 6 months? So there's a window. It's looking through the windscreen, not looking in the rearview mirror. Where is this company going in the next 6 months? And if you predict your cash flow position, whether it's your loan covenants to the banks, whether you are trading in a situation where you can continue to pay your suppliers or not, as long as you can predict where it's going and early enough on the distress curve, then you've got your predictors in place. And where if you do bring in an astute business rescue practitioner, or let's say a professional, someone who looks at it very, very clinically, independently so, and advises the board, yes, this company is a candidate for business rescue, there's maybe post-commencement finance in the system, the banks are prepared to back you, your suppliers are in here, and your trade unions are going to back you as well. As long as you understand the system, I think business rescue is an effective tool in South Africa, and like it is in other jurisdictions around the world.
I agree, and and also you can always combine it with just more information in general. You know, having just boards or even just managers of companies being more informed about what's happening around the world in their business, in their sector. I think the more information and signals you have, first of all, the less likely you are to face a situation of distress, but sometimes it's inevitable because there's just how the economy works. And then to know that there are further steps to recognize what you can do with a company.
Yeah, and Aroni, the one thing that is a very important fact is never let your banks be the last to know that you're filing for business rescue. They get really, really upset. So you've got to keep your creditors close, and particularly your bank that's providing you with your facilities, your overdraft, etc. If they find out that the business rescue practitioner is the first person to phone them, they're not happy. So it's about keeping your creditors close, consulting with them, telling them where this company is going, and then obviously the outcomes will be a lot better.
Yeah. So yeah, be honest, which is not always easy when you're like running a company. I can understand that. Well, thanks, Eric. That was a very rich conversation. I learned a lot personally on the liquidation, insolvency, and business rescue front in South Africa. So for me, I'm just sad that I don't have more data on this. There is not much data at the macro level on business rescue, unfortunately. I hope one day there will be. I mean, South African statistics are very good, but it's true that statistics on insolvencies in general at the global level, they're very hard to get. Because some of them are protected by laws and so on and so forth. So for us, it's a bit difficult to grasp with little data. I'll open the floor to questions. It can be questions for Eric. It can be for me as well on the economic presentation, although it was a while back. But thank you so much, Eric, for the conversation. And yeah, who wants?
Yeah, I mean, if you don't mind, I can just start with a question. I think business rescue in our business and what we do in a day-to-day is a big topic of conversation. How do you, because obviously continuous supply is a big thing. Now companies entered business rescue. Obviously your suppliers are concerned because they've already got skin in the game. They don't want to put more skin in the game and potentially lose more. How do you, I mean, what's the best way to tackle that? Because you don't, you're in for, let's call it R1 million. Now you need to supply more, but there's no guarantee that you're going to get that. How do you build that trust with your suppliers?
Very important question. And it comes down to what I mentioned earlier, and that's post-commencement finance. So anyone who provides goods and services to a company post-commencement of business rescue would become a post-commencement financier. And if the business rescue practitioner is willing to accept goods and services from you, you would then be pushed to the top of the pile when it comes to repayment. So it's very important. Your historical debt gets parked, that gets compromised. But your post-commencement debt, in other words, continued trade, while you're a supplier, you would be preferent and you'd be paid before anybody else. But a supplier's got to make a very hard decision. Obviously, they often are already exposed. They're owed money. They're going to get their historical debt compromised. Now they've got to make the call. Are they going to continue to supply the company? That's where the business rescue practitioner is so critical. He's got to instill confidence in the stakeholders to back this company for whatever reason. Maybe there's a plan that makes sense, that will be backed by the banks, for example, and therefore they will continue to supply goods and services in the business rescue. But it's quite technical, it's quite complex, and if you are going to do that, I would make sure everything is confirmed and agreed to properly. Phone your lawyer.
All right, I don't know if we've got, okay, we've got a couple of people.
Oh. Sure. Hello. I'd like to know, how long does or can a company stay in business rescue for?
How long?
How long?
Yeah, so interesting question. 3 months, but it never happens. It goes well beyond 3 months. The Act said 3 months for a reason. You can't be in business rescue forever. It takes too long. People are not going to back the company forever. So I've seen some companies go into rescue for, let's say, 5-6 months and then exit. I've seen some go in for 2 years. I think Comair, as an airline, remember Comair ran Kulula and British Airways. I was very involved in that matter. It was in rescue for close on 18 months to 2 years. And because of COVID and because of shutdowns, the company just couldn't continue to trade and it went into liquidation. So it depends on how much post-commencement finance is in place. Are creditors willing to extend the publication of the plan, which they have to agree to? And generally, creditors are not going to rush the business rescue practitioner. If there's a lifeline in place on post-commencement finance, and if there is a way forward from a rescue plan which makes sense, creditors, suppliers generally back the extension of the plan, and eventually the plan will get voted in, gets implemented, and then the business rescue practitioner would exit. So it really is a very difficult question to answer, but it's somewhere between 3 months and I would say maximum 18 months to 2 years.
Hi, how are you? Mr. Stand Up. Oh gosh, I don't like standing up. How are you? So basically, I wanted to just touch on Aroni's first question with regard to the business rescue. In the Companies Act, is there a clear guidance to when a director can be held liable from a delinquent perspective? And the reason I'm asking that, I think 2 years ago, Dudu Mieni from the SAA was the first major one that was held as a delinquent director. But we don't see that a lot with other smaller or big companies, to a point where you see a director, big liquidating company here, then go to the next one, and they have a chain of company which they actually are not actually making them successful. So my question there is that, is there a measurement or a level where you can actually say, okay, you are delinquent, we need to kind of file for that, and then you can't operate as a director anymore? Thanks.
Thanks very much. Can I answer that? Very good question. And the case you're referring to is South African Airways, where Dudu Mayene was declared a delinquent director, and there's a whole judgment there. You can read it and understand why. She was declared a delinquent director. Now, you've got to go to court, which is expensive. You've got to bring a court application. You've got to brief advocates. And yes, if it's big enough, it makes sense to declare someone a delinquent director so that they cannot take an appointment going forward. There are some aspects of the Companies Act which have been built in to prevent directors from continuing to trade as they have done before. In fact, there is a provision which says if a director's been a director or in charge of a company that's in a situation where at least 2 times it has had companies that have gone into liquidation and where creditors were not paid in full, that individual is not entitled to take on the appointment on the 3rd occasion as a director. Not many people know about that provision, and there's been no case law on it at all, but it's there. And then Section 22 talks about reckless trading, and where companies should not trade recklessly, and where directors can be held personally liable in terms of 218 of the Companies Act, Section 218, as well as criminally liable as well. The problem is we don't see enough of it. We don't see enough of, let's say, and I'm being quite frank about it, the banks prosecuting directors who shouldn't be directors going forward. And maybe other creditors and suppliers where they have had a situation where directors have not been held personally liable. But remember, business rescue is a buffer. In the old days, you had liquidation and then they would go after the directors. Here, business rescue provides directors with a bit of a buffer or a lifeline to get out of that personal liability position because of the system. So it's a bit of a two-edged sword, but I think that's really why we haven't seen a lot of directors being prosecuted either civilly or criminally in South Africa. So it was the question, who can do it? Yes, the business practitioner is obligated in terms of the act to report irregularities, breaches of legislation. Again, we haven't seen a fortune of that. It has happened. And also the business rescue practitioner can go to court to remove directors who are inhibiting the ability of that practitioner to do his work properly and push out a business rescue plan. Again, I'd like to see more of it. But, generally, directors abandon ship. Once a company goes into rescue, you don't see them, particularly non-executive directors. They don't. You see them resigning very, very quickly. They're not going to get their free lunch at the board meeting, so they're gone. So there is a system in place to deal with directors, either delinquent or otherwise, in the Companies Act.
I have a lot of questions and a comment. On the business rescue side, I'm just curious, from an ethical obligation, once an organization has gone through business rescue and being able to implement whatever recommendations come from the plans, but then subsequently goes back and maybe does not succeed, I will imagine that the first time around, once it's now handed back to the directors, they have a legal obligation to ensure that whatever the recommendations get implemented. But does the business practitioner have an ethical obligation where the directors are not doing what they're supposed to have done or to do, to actually seek other platforms to ensure that the directors are being held accountable? That's my first question. My second question, you spoke about SOEs. And we also understand the amount of impact that the whole country gets affected by when the SOEs actually go down under. From your experience, what's the openness of, from a government point of view, to consider privatization or even perhaps IPOs? Because I think in South Africa, we are probably the only country where, well, we're not the only, but I know that there are countries where SOEs are actually publicly listed. And for the right reasons, governance, because most of the time this is where the issues normally happens. The readiness, the appetite from the public sector, now being the government, to once they've gone through business rescue, or even when they are going through that, how open are they to actually being privatized, and also in particular even the IPO's process? And the last question to you, because I imagine you're sitting with a lot of data in terms of what causes this, what can be done differently. Where's the feedback loop, especially when it comes to regulatory and other economic reforms? Because just looking at what we've just gone through in terms of the economic geopolitical landscape, it's frightening what's going to happen in the next few years. So maybe what we've seen is nothing compared to what we are likely to see going forward, especially if South Africa do not move forward with those reforms. So where is the feedback loop? Do you have any where you say, this is what we are seeing in the industry, and we believe if these are relaxed, it will help maybe stimulate the economy, preservation of jobs and the like? where does that happen? Because I imagine you're sitting with a lot of useful data, but what happens with that data? And a comment, I do promise you that directors, at least the ones that know their legal responsibilities and are doing this for the right reasons, they want to know. And before you leave this platform, I can promise you that I can get you 3 platforms, associations of directors, where they will want to hear from you. So it's not all the directors. I just wanted to clear that out.
Is that an invitation?
Yes, it is. Thank you.
No, thanks for those questions. Let me work backwards. Firstly, I have partnered with, at Werksmans, my law firm, we partnered with the Institute of Directors late last year. We pushed out in a publication about exactly what you're talking about, trying to educate directors on their legal obligations in a scenario of business rescue. So that's an ongoing discussion which needs to happen, there's no doubt. Just talking about the regulator, and I'm working backwards, I hope I remember all your points. SIPSI have got a very strong role to play in business rescue, but they don't have enough teeth, or let's say the willingness to get really involved. Now, there's a section in the Companies Act, section 22.3, which says if SIPSI has a report from a creditor that they're not being paid, they can in fact report a company to SIPSI, and SIPSI can issue a compliance notice forcing the company to explain why they're not paying that creditor. And we're not seeing enough of SIPSI being involved at that level. And just imagine, if they were really involved, you'd see a lot more companies file for rescue a lot earlier, and where directors would have to answer to SIPSI. I would love to see SIPSI more involved. They've got really good people at SIPSI. I've engaged with them very, very often, particularly through SARIPA, the organization I'm involved with. And there's a lot of discussion that needs to happen with SIPSI. On SOEs, you know, when you look at SAA went into rescue, and the late Pravin Gordon was very involved in that matter with 2 very competent business rescue practitioners. And yes, it was a rocky road. It was a very difficult and emotional road because the taxpayer was paying for the resuscitation of 1 airline out of, let's say, 6 that were flying at that time. SAA is still flying. Yes, it might not be making the profits that it was, but that is let's say, a quasi-successful business rescue. When you look at the South African Post Office as an opposite example, here the Post Office practitioners have been asking for their final payment of 3.8 billion, and government have said, we're not paying. We don't want to keep the Post Office going. Now, that's still a debate whether or not that's going to happen, but that lifeline has not come from government. So I think government, particularly through the GNU, are becoming far more astute as to which SOEs should be backed and which shouldn't be backed. And I think the jury's out on the Post Office. I might be wrong, but we'll have to see what happens with government funding. Now, SABC, Denel, PRASA, all of those companies continue to make losses, and government has to make a call. Do these SOEs get privatized, like SAA nearly was, and then they fell off the bus? There was a private player there for a period of time. And then your first question, I've forgotten. I think it was about directors. Yes. Yes. Yeah. So I always talk about the rear view mirror and the windscreen. Business rescue is looking through the windscreen. Liquidation is looking in the rear view mirror. The company goes into liquidation, the liquidator has to investigate the manner in which the directors ran the company. Practitioners do not have the time. They don't have the ability to run an inquiry. It's a fast-track process, as we explained earlier. It should be 3 months, but it's not. So they don't really have time to interrogate directors on their past misdemeanors or how they ran the company historically. So we don't really see business rescue practitioners, once they've exited, reporting directors to the authorities. It's just not part of that process. Unless, of course, directors have been removed, and yes, they can be reported to the regulators or maybe to the NPA or whatever it might be. I hope I've answered all your questions. What was the comment? Yeah, you can only do that really through the Institute of Directors. I don't see any other forum. As I said earlier, if I had to hold a seminar for directors of distressed companies, no one's going to pitch up here. So, that's really the challenge. I hope I've dealt with that. Thank you.
Thank you. Hi. Just a simple question. We've seen a lot of media publications around business rescue practitioners being struck off the roll. Under what circumstances does that happen? And secondly, is that we've seen cases where, as you said, a case or a scenario should take between 3 and 18 months the most, but others run for longer. Does a company have recourse to actually request for a new practitioner? Thank you.
So on the second question, a new practitioner, someone who is kicking the can down the road and is earning fees, because you're entitled to charge on an hourly basis, and is not publishing a plan. It's up to the creditors to get together to remove that business rescue practitioner, either by way of correspondence or writing letters that are extremely aggressive, or going to court to remove the practitioner. So that certainly is built into the Act. I don't think any creditor should accept any practitioner that is doing that, that's not publishing a plan or not giving an explanation as to why a plan's not being published within a particular time frame. Now, we have had some judgments quite recently against practitioners who have misbehaved. And the problem for those practitioners is if you are going to have a license, it can be revoked by SIPSI if you have an adverse judgment against you. And what's even worse is you have to belong to one of the accredited organizations, like the Law Society, like SARIPA, like the TMA, in order to get a license. And if you've had an adverse judgment against you, you're probably not going to be a fit and proper person to belong to one of those organizations. So there certainly is, let's say, pushback against errant directors, I like to call errant business rescue practitioners rather. And the system is working, and I do think that those business rescue practitioners who have not done their job properly are being brought, to a situation where they are going to lose their licenses.
Hi, Eric, thanks. Two quick questions. Just what percentage of businesses in business rescue actually go into liquidation? Because I think that shows the success rate, basically, of whether the system's working or not.
Yeah, I wish I had the answer to that.
From your experience,
Firstly, SIPSI, we've been addressing this issue on statistics with them. Aroni put up some slides earlier on Stats South Africa, on liquidation. So there's a lot of information on liquidations as to which sectors of companies are going into liquidations. Now, unfortunately, the level of statistics coming out of SIPSI is very, very poor. And that is something which we've taken up with them. And they need to actually go out to the business rescue practitioners and understand why business rescues were successful or weren't successful. What were the reasons? Was it management? Was it pushback by the board, et cetera, et cetera? And I do think that that is a gap which needs to be filled, because that kind of data is incredibly important to economists like Aroni and others as to understanding why are companies defaulting into liquidation and rather not staying or being rescued through a business rescue process. But the other problem is what someone else raised is those business rescue practitioners need to take a decision much earlier to default into liquidation if it's not working. You cannot kick the can down the road indefinitely when a business rescue is not working, you aren't able to file a plan or get a plan supported, and there's no post-commencement finance in the system. Those practitioners have to put the company into liquidation. And there will be a time where a practitioner is going to be sued personally for not having done that, not having put a company into liquidation at a much earlier stage?
Yeah, well, that was the second question. I mean, how many companies have gone directly into liquidation without going through the business process, the business rescue process?
Yeah, I think that the business rescue practitioner himself has a large obligation to do what we call a pre-assessment. You come in, you sit with the board, you understand what this company looks like, you understand the extent of the distress, how far down that distress curve are you, and are you a candidate for rescue or not? And the practitioner needs to be brave enough to say, you know what, I'm not taking on this appointment. This company should default into liquidation. There's no chance of a rescue, and let the company rather go into liquidation. The problem, of course, is practitioners take on these matters because they're earning fees. And that's something which the organizations like a Saripa are trying to police quite heavily.
But I presume a company can bypass business rescue
Yes.
totally and just go straight into liquidation.
Yes,
so
absolutely.
you wouldn't know.
So just to answer this question, you asked as to what number of companies actually exit business rescue. According to the Reserve Bank's website, it's between 20 and 30%. Those that actually make it out of business rescue. So you're looking at between 60 to 80 that don't exit.
Hey there, Eric. Do you not think that auditors should be compelled to report companies that are supposed to be in business rescue?
So I've spoken at SAICA many times, and I've tried to explain to the auditors that they're probably the first to know that the company is no longer a going concern. The problem is, what do they do about it? They obviously won't sign off on the financials, which is a big issue, particularly if it's an SOE and its audited financials aren't being signed off. But they should be playing a much larger role in saying to the board, this company is financially distressed. There's no way out. You need to go and take proper advice and go and get advice on whether the company should go into rescue or maybe even liquidation. The problem is they lose an audit client. So there's not a huge rush for auditors to say to their clients, you know, go and get proper advice on rescue or liquidation. But I must say that having engaged with SAICA, there's a much bigger awareness of that duty to at least tell directors, as auditors now, what their obligations are and what they should be thinking about.
Perhaps they should apply the moment their fees have been paid.
Maybe.
This is on the earlier presentation, and this is my assessment. So I'd just like maybe just to correct me if I see things incorrectly. The issue of deglobalization, right? My view is that it seems to be peddled mainly by very few countries, maybe specifically the US, for reasons that I think I understood. My assessment is that notwithstanding the fact that this seems to be the fact that the US is earmarking on becoming more localized and perhaps issuing tariffs to a number of countries, my assessment is that the rest of the world is still for globalization. And perhaps that is still something that needs to be discussed through the relevant forums like your G20 or UN or wherever you want to go, World Economic Forum. So am I correct to say it is unlikely that the world is at a stage where they are now, or they can actually deglobalize? It doesn't seem like there's economies that can sustain themselves without, the world trade. Is my assessment correct in that respect? And then this is a question and a comment. I think what concerns me about the country is you spoke a lot about how China did it, even how India is doing it. Where I think I found South Africa, the phase that it's at is we don't have strategic assets that we said this is what we're going to do as a country. We also are constrained in terms of growing the revenues. There's not more tax that we can actually impose because, everyone is like struggling to find the money that is to grow the economy, basically. So my concern is or rather comment, there has to be some concessions. And perhaps in order to be able to leverage the next phase, because I think we are behind, and I think we must admit that. And in order to become players in global trade, we have to say this is what we are going to do, this is what we're going to specialize in. I still don't know how we're going to get the money because our fiscus is constrained. So my concern is, how then do we begin to make those concessions digestible by the whole, especially taking into account that we're a very labor-intensive country. And there's a huge burden on the government to actually, for social security. How did other countries do it such that there was a universal understanding that this is what the country wants to do and actually buy into it without frustrating possibly those efforts, either of the private sector or the business sector, to be focused in specific strategic assets. And I think in our case, I'm not sure if we can, I still think we can still do much, even with our mining, but it will take some specialization and beneficiation, and we are not close. That's my only concern. South Africa is not close to be competitive with the rest of the world. In order to do so, there's going to be sacrifices. How do we get everyone to rally around what's in the benefits of the country in the medium to long term? Thank you.
So first of all, on the subject of deglobalization, actually, I don't like the term of deglobalization that much because we're not going towards deglobalization. We're going towards a different type of globalization, and perhaps, the fact is that maybe we are attaining a plateau of globalization because trade is not increasing anymore in proportion. But there are still very strong trade flows. The global economy is highly integrated. And as you were saying, trade is going to continue. So even in this world where we have more protectionism, it doesn't mean that, suddenly you're in a state where you're deglobalizing. It's just that it means that some economies are trying in this phase, because it's also a cycle, to concentrate more on their domestic economy, and also there's a lot of politics involved behind it, so there's all of that. But ultimately, it is impossible for any economy right now to be able to operate on its own. So trade flows will remain. It's just that they are likely to change into nature. There's likely to be a shift in the value chains, a shift in the trade links. As you were saying, perhaps a recognition of how to integrate and how to specialize to adapt to these new trade flows. And I'm saying new trade flows of which I don't know of what nature. So one example is between the US and China, that at some point you can see that direct trade between the two countries did drop quite substantially and will continue to drop. But then you saw that the trade links, for instance, between Vietnam and the US or Mexico and the US actually increased in that period because they were serving as, transshipment basically hubs. That is also likely to be met into some way. So then the question is, the fact is that in this trade war, for instance, for the US, it's not as if the US is looking to really cut off its trade relationship with anyone. It just wants to protect itself mostly against Chinese products and transshipment of Chinese products, but they're still trading heavily with the rest of the world. So then the question becomes, and once again, the Donald Trump era is now, it's normally 4 years, and then what happens? So I think deglobalization it's way too early to call on that. Yes, there is a rise in protectionism just because of the nature of how politics and geopolitics are, and also because we're in a more geopolitically fragmented world with a rise in conflictuality, with just a very quickly and a shifting environment with a lot of crises. So in a time where you have a succession of crises, I think that it would be, within brackets, expected that some countries turn more protectionist just because of the impact of these global shocks. But there's still going to be trade and lots of trade between countries. It's just that its nature and its flows maybe are going to shift. And for South Africa, so the thing is that I think that South Africa is not really comparable to India or China in the categories of the BRICS group, right? It's just like the economic structures are so different, the size of the economies are so different, even between India and China, the political system is different, the whole economic policy that were behind Chinese growth were very specific in terms of what they wanted to develop, how they wanted to increase the weight of China in the world, and which they managed to achieve also because they have a political system that enables it. You can't, in my opinion, as a democracy, do what China did and do what China is doing. You need China's political model to be able to do that and to be able to force it through, kind of. So I think that that's very important, which is why India's drivers are completely different, and they're going to continue to be completely different than China. And for South Africa, I mean, yes, I think perhaps that for South Africa, you're right in the sense that there needs to be a thinking, and in the session in this morning we spoke about it a bit, there needs to be a focus at some point on how does South Africa integrate into this environment. In the longer term, it is known that some of the markets that are important export markets for South Africa are not going to be growing in demand. So, for instance, the EU, but also China in the longer term, just because of demographics and how mature markets have less growth. So then, where do you focus your trade specialization? And on what you were saying is that how do you make it accept that, yes, perhaps there needs to be a strategic change, like in the trade relationships? I think that first and foremost, what the South Africans are expecting right now is that you take care of the domestic issues first. You acknowledge that, yes, some industries are going to be suffering, and it's already the case, but that is the case of an open economy, and you focus on the matter at hand, and the matter at hand is restoring the infrastructure, is starting to produce results in the coming years in terms of growth, in terms of employment, in terms of the social indicators. And that is how also you can then start to expect that your population will understand moving forward into other strategies. But unless you respond to the basic needs that they have expressed through vote, I mean, that's what they did. They expressed it through vote, and now they have expectations. So I think it starts there, and then perhaps you can start to explain that, yes, I mean, some industries, some heavy industries are going to have to face structural shifts. But at the same time, once again, if you have implemented the policies to reform the economy, that means that you have also probably created some space for the creation of new industries. You continue to develop industries that South Africa is specialized in the service sector, for instance, in the banking, in the financial sector, the tech sector, the pharmaceutical sectors. I mean, there is a lot of industries. So, and then maybe at some point you do have to acknowledge that some of the sectors are not going to remain competitive unless you expand into growing markets. But and the growing markets are the markets that are next in the continent, right? I mean, the answer in the long term is that, you know, South Africa starts to become an exporting base for the rest of the African continent, right? But that needs to go hand in hand with regional integration and growth. So I think that is how, like, I'm just speaking here. I'm not, I'm not in the public authorities, but I think that they do have it in mind. I mean, there are definitely people in the government, in the treasury, in the central bank, in the institutions who have this in mind, but I think that it needs to be in this step-by-step basis. And so for now, I think that the commitment really has to be on what has been promised at the political level to correct like the very pressing issues of the South African economy, first and foremost, before concentrating on how do we integrate. I mean, yeah, it's going to be a bit difficult for some industries, but you know, they're going to be able to navigate it. Most countries will be able to navigate it. So, yeah. Economic agents, they adapt. Although times become more difficult, I mean, the world continues to turn. So I think it's the same for South Africa, right?
All right, Aroni, Eric, thank you very much for that. I don't think we've got any other questions. So I think just a big thank you, Aroni, for joining us, Eric, for joining us here today. And obviously to all our brokers and partners that have made it here today, a big thank you to everybody. And yeah, there'll be a couple of snacks on the way out, and hope everybody has a good afternoon and drive safely. Thanks, everybody.